Hello, and welcome to our training on for the San Mateo County Continuum of Care on Continuum of Care Program Compliance. Today, your presenters are myself, Philo Lindner, and my colleague, Monica Porter. We're from Home Base, which is a nonprofit organization that provides technical assistance and training to housing and homeless services providers in San Mateo County. The goal of today's training is to provide a high-level overview of common CoC compliance issues for CoC-funded programs. Although this is a pre-recorded online training, we want to invite you to reach out to us at any time at sanmateo@homebasecc.org, which is our team email address, with any questions about your particular program or this training. We will also post links below this recording on YouTube so that you can check out any of these additional resources for more information about CoC program compliance. So today's CoC compliance training focuses on common compliance issues. And these, the common compliance issues that we're going to be focused on are going to be sort of tailored to what you would be looking for if you were doing a client case file review, right? So focusing on some of the key items that you need to be maintaining in your client's case files. So as such, we're going to be focusing on the following issues: documenting client program eligibility. So understanding how to document categories 1 and 4 of HUD's homeless definition, understanding how to document chronic homelessness, and spending a few moments on important record-keeping requirements and best practices. We're then going to move into talking about fair market rent, FMR, and rent reasonableness determinations. We're going to talk about client income and rent contribution calculations, lease requirements for client units, and housing quality inspections for client units as well. So moving right into eligibility documentation. In this section of the training, as I said, we're going to talk about documenting homeless status for the purpose of establishing CoC program eligibility. And just a reminder that this is a high-level overview of this issue, so please reach out to us if you have questions. You can also check out our longer, more in-depth eligibility documentation training, which is available on our YouTube channel and will be linked to at the end of this section. So why is it so important to document your client's program eligibility? We recognize this is not the most fun part of your job, but it's very, very important because when you take the time and effort to properly document your client's program eligibility, you're doing a couple of things. First of all, you're ensuring that your project's resources are being provided to the people who need them the most, as determined by HUD. You're helping prevent costly HUD monitoring findings based on inadequate documentation. And you're learning about your client and how best to serve them, because really in the process of understanding what documents to get and actually getting those documents, you're going to have an opportunity to get to know your client's history and experiences and where they're coming from, and therefore potentially how to help them move forward. A few key concepts we wanted to provide you with before we move into the details. So HUD has defined 4 categories under which households are considered homeless for the purposes of CoC-funded projects. And those are what I'm going to get into in a moment. HUD has also published a separate definition of chronic homelessness, which my colleague Monica is going to get into a little bit later. And why do you need to know these definitions? Well, whether your client is eligible for your program depends on whether their circumstances align with the HUD definition of homelessness that your program serves. And that's a very important point to remember. And some more key concepts. So who can your program serve, right? That's going to depend upon a few things. First of all, your program type. Right? Are you a rapid rehousing program, permanent supportive housing program, or transitional housing program? What is in your HUD grant agreement? And when were you funded? So the bottom line is that your supervisor should have this information, but if you run into issues or have questions, you can feel free to contact us. We can help you figure out who you can serve. The last point here is really that each definition of homelessness requires somewhat different documentation, but they all have one thing in common, which is that HUD has an order of priority for the types of ways you could document each category of homelessness, and HUD always prefers third-party documentation. Right, starting with HUD's 4 categories of homelessness. So again, not to be confused with the definition of chronic homelessness, which we'll discuss in a moment. I just wanted to note here that there are also other definitions of homelessness that other government programs and agencies use. For example, the McKinney-Vento definition used in schools. But today we're just going to focus on the ones applying to CoC funded programs. This slide provides an overview of HUD's 4 homeless categories. So the first one is category 1, which is literally homeless. Category 2 is an individual or family who will imminently lose their primary nighttime residence with no subsequent residence resources or support networks. Category 3 is unaccompanied youth or family who meet the homeless definition under another federal statute. And category 4, which is an individual or family fleeing or attempting to flee domestic violence. And domestic violence here includes, the term domestic violence here includes dating violence, sexual assault, stalking, human trafficking, and other dangerous or life-threatening conditions that relate to violence against the individual or a family member that might make them afraid to return to their primary nighttime residence. And on a later slide, that's spelled out as well. So today, we're only going to focus on documenting categories 1 and 4 because those are the 2 that you are most likely to need to document in San Mateo County. Getting into the categories now, category 1 is for households that are literally homeless, as I stated. And literally homeless means experiencing or lacking a fixed, regular, adequate nighttime residence. There are 3 subcategories of literal homelessness, and people can fit into any one of these subcategories to be considered literally homeless. So if your program is allowed to serve category 1 folks, you can serve households that fit into any one of these 3 subcategories. So the 3 subcategories are subcategory A, which is having a primary nighttime residence that is a public or private place not meant for human habitation. This includes cars, parks, abandoned buildings, buses or train stations, or campgrounds. Subcategory B is folks residing in a shelter designated to provide temporary living arrangements. And examples of that would be emergency shelters, some transitional housing, and hotels and motels paid for by charitable organizations or government programs. Unfortunately, hotels and motels paid for by the household or by other private entities, such as family or friends, do not count. Subcategory C is those people who are exiting an institution after 90 days or less, where immediately before entering that institution, that person either resided in an emergency shelter or place not meant for human habitation. And here, when HUD says institution, they mean, for example, a hospital, jail or prison, or an inpatient treatment center. And again, each subcategory has its own documentation requirements, which we will get into now. Subcategory A, again, this refers to an individual or family who has a primary nighttime residence that is a public or private place not meant for human habitation. So in order to document clients' eligibility for this subcategory, you are going to want one of the following documents: a written observation by an outreach worker of the conditions where the individual or family was living, or a written referral by another housing or service provider, or a certification by the individual or head of household seeking assistance that they meet this definition. Subcategory B has to do with temporary living arrangements. So again, this covers households living in publicly or privately operated shelters designated to provide temporary living arrangements. Living in publicly or privately operated places that provide temporary living arrangements, such as shelters. And actually, the documentation requirements for subcategory B are the same as for subcategory A. So you're going to want one of the following items. Again, a written observation by an outreach worker of the conditions where the person was residing, written referral by another housing or service provider, or a certification by the household that they meet this definition. All right, so subcategory C. Um, Subcategory C, again, is for people who are exiting an institution after 90 days or less, where that person resided in an emergency shelter or place not meant for human habitation immediately before entering that institution. So here you're going to need basically two documents. The first one is going to show that the person was residing in a place not meant for human habitation or emergency shelter before entering the institution. And again, you can rely on one of those three documents that you rely upon with categories A and B. So written observation by an outreach worker, written referral, or self-certification. And then you're also going to need a document showing the length of stay in the institution. So discharge paperwork from the institution, or a written or oral referral that is documented in the case file from a social worker, case manager, or other official from the institution with start and end dates. Or if those are unobtainable, a written record of the intake's due diligence to obtain that evidence, plus a self-certification by the individual seeking assistance that they exited or that they are exiting or have just exited an institution where they resided in for 90 days or less. All right, moving on from category 1 to category 4 on how to document eligibility for it. So category 4, the definition of homelessness here is any individual or family who is fleeing or is attempting to flee domestic violence, has no other residence. Sorry, for some reason the slides keep advancing without my pushing buttons. So category 4 is an individual or family who is fleeing or is attempting to flee domestic violence, has no other residence, and lacks the resources or support networks to obtain other permanent housing. And again, as I previously stated, here's the definition of domestic violence that you're going to be applying. So if your program is allowed to serve people in category 4, you will document their status as follows, depending on if your organization is what is known as a victim service provider or if it's not. So HUD defines a victim service provider as a private nonprofit organization whose primary mission is to provide direct services to survivors of domestic violence. So both types of providers, victim service providers and non-victim service providers, will both need a household member's oral statement that they are fleeing domestic violence, that no subsequent residence has been identified, and that they lack the resources and support networks needed to obtain housing. And then for victim service providers, the oral statement must be documented and certified by the head of household or the intake worker. If your organization is not a victim service provider, the oral statement must be documented by certification by the individual or head of household that the oral statement is true and complete, and if safety would not be jeopardized, this abuse must be verified either by a written observation by the intake worker or a written referral from an organization from whom the individual or household or head of household has sought assistance. An example of one of those organizations might be a housing or service provider, a social worker, a healthcare provider, law enforcement agency, legal assistance provider, pastoral counselor, or any other organization from whom they've sought assistance for domestic violence. And the written referral or observation need only include the minimum amount of information necessary to document that they're fleeing or attempting to flee. And when considering obtaining these referrals, just the safety of the client is really the utmost priority. So the client has the final say on whether or not it's safe for you to reach out to these third parties to get this documentation. So always defer to the client's determination about what's safe before contacting third parties. All right, and I am now going to hand it over to my colleague Monica, who is going to talk about chronic homelessness.
Great. Thank you, Byla. So let's start on the next slide with the definition of chronic homelessness. Chronic homelessness is defined as a homeless individual with a disability who lives in a place not meant for human habitation, safe haven, or emergency shelter, and has been homeless continuously for at least 12 months or on at least 4 separate occasions in the last 3 years, as long as the combined occasions equal at least 12 months. The definition of chronically homeless can apply to individuals or families. For a family to be considered chronically homeless, it would need to have an adult head of household, or if there is no adult in the family, a minor head of household who meets these criteria for chronic homelessness. When documenting a client's eligibility in a client file, you'll need to have documentation of each element: that the client has a disability at the time of program entry, that the client is currently homeless, and has a history of homelessness. So on the next slide, let's break down how to document each element. To qualify as a person with a disability for purposes of meeting the definition of chronically homeless for CoC funding, the client has to have a developmental disability, HIV/AIDS, or a physical, mental, or emotional impairment that is expected to be of long continuing or indefinite duration and impedes on their ability to live independently. For documentation purposes, the client must have a disability at the time of project entry. On the next slide, we'll recall that to be considered chronically homeless, the individual or family has to have been homeless continuously for at least 12 months or on at least 4 separate occasions in the last 3 years, as long as the combined occasions equal at least 12 months. A break in homelessness is 7 or more consecutive nights and could be something like couch surfing or being in an institution such as a jail, hospital, or treatment facility for 90 days or more. A stay in an institution does not constitute a break in homelessness if the client stayed there for fewer than 90 days and the client was homeless and living in streets or shelter immediately prior. When documenting length of time homeless in a client file, you'll want to make sure the client file tells a complete story and includes documentation of both the episodes of homelessness and any breaks. And of course, make sure you've covered that the client is currently homeless. So now I'll turn it back to Byla to talk to us about record-keeping requirements and best practices.
All right. So again, before moving on to our next topic, we just wanted to provide you with HUD's record-keeping requirements and some tips on how to keep these records. So starting with records retention requirements. The CoC program interim rule requires recipient or subrecipients must keep these records for 5 years after the end of the then current grant term. This is in part important so that when HUD comes to monitor, you have all the documentations necessary on file. This slide provides some record-keeping tips that will make your lives easier, especially during HUD monitoring. So you should always maintain organized, user-friendly case files so that any person reviewing the file can navigate them quickly. One thing that we recommend is using table of contents and tabs in case files. That way, for example, if a HUD monitor is looking for something particular, they'll know exactly where to find it, and they don't have to worry about missing it. You don't have to worry about them missing it. And also you don't have to worry about them, rifling through the file and, kind of missing something or identifying potential other issues. So again, you're going to want to include as much detail as possible with each piece of evidence you include in the case file. So never assume that someone reading the file can fill in the blanks. Never assume that they know how your agency keeps things in other places, or understand something particular about an agency change that happened in the past. For example, that you inherited the file from another agency. Always make sure to provide as much detail as possible about the case file history and everything that occurred. And when in doubt, just write it out. If you have a thought about, is this relevant, you might as well just document it in case. And again, as Monica said, you're going to want to tell a complete story in your case files. So for example, if you've been trying to reach a third party to obtain an eligibility document, but you haven't been able to actually make contact, or they haven't sent it to you, and you've sort of exhausted all of your efforts, just make sure that you document every single effort that you made to try to contact that third party, so that HUD knows that you've done your due diligence. And again, you're going to want to watch out for details that undercut your evidence. So document your efforts to resolve any conflicting details that have to do with eligibility documentation. So what if existing documentation is not compliant? And this happens sometimes. And while circumstances may vary, though, programs should take immediate action to address issues, right? So develop a plan to bring the program into compliance, remedy documentation for as many active clients as possible, and communicate with your field office about the issue and the steps you're taking to address and prevent reoccurrence of these issues. So as I mentioned before, this is sort of a shorter version of a presentation that we have done in the past. The longer version of the CoC program eligibility training that we offer can be found on our YouTube channel. And I provided the URL to get to that training right here. We'll also provide a link to it as well at the bottom of this training, so you can click on that. Okay, I'm going to turn it back to Monica for the FMR and rent reasonableness.
Great, thanks, Byla. So to start with the definition of fair market rent, or FMR for short, is a HUD-established estimate of rent in metro and non-metro areas across the country. HUD updates FMR annually in October, and the purpose of FMR is to ensure a reasonable supply of adequate rental housing is available to program participants. It's meant to be high enough for a selection of units and neighborhoods, but low enough to maximize households served. On the next slide, we'll consider the 2019 and 2020 FMRs for the San Francisco Metro FMR area, which includes San Mateo County, and is found on the HUD website at the URL at the bottom of the slide. HUD's website provides FMRs for a number of years. To make sure you're looking at the right FMR for your project, you'll want to know what your project's start and end date is. For example, if your project has a start date of September 1, 2019, then you should use the 2019 FMR numbers until the end of that project, which would be August 31st, 2020. FMR is typically lower than market rent, especially in California. So aligning your start and end date with the FMR publications, which typically follow the federal fiscal year, can be beneficial in your ability to better keep up with local rents. On the next slide, we'll turn our attention to the definition of rent reasonableness. This means that rent paid with CoC funds must be reasonable as compared to rents paid for similar unassisted units in the same area. By similar, we mean location, size, quality, age, amenities, and utilities. On the next slide, we'll take a look at the limits on FMR and rent reasonableness. The impact of FMR and rent reasonableness on the amount a program can spend from a CoC budget depends on the type of project. In a leasing project, the amount spent from a CoC leasing budget cannot exceed either FMR or rent reasonableness, and therefore is capped at the lower of the two. So if you have a 1-bedroom unit in a leasing project where the reasonable rent is $2,600 and the FMR is $2,500, the project can only spend up to $2,500 on the unit. The $100 difference would need to be paid from other resources. Conversely, in a rental assistance project, the rent can exceed FMR. It just can't exceed rent reasonableness. So the amount the project can spend from its CoC rental assistance budget can go up to rent reasonableness. However, unlike leasing programs, which can use non-CoC funds to cover the balance, rental assistance programs are prohibited from subsidizing units that exceed rent reasonableness. Also, in rental assistance projects must continue to serve the contracted number of recipients. So if the project pays rent beyond FMR levels for some units, they'll need to make sure they have enough funding to serve the contracted number of program participants for the remainder of the grant term. This could come from participant rent contributions or from lower rents in other areas of the community. Before we move on, I want to just add a brief asterisk here. We are taping this training on June 25th, 2020. In response to the COVID-19 pandemic, HUD has made available several temporary waivers on CoC programs. Some of these waivers impact the FMR and rent reasonableness restrictions on leasing and rental assistance dollars. So you'll want to check with your agency lead if you're not sure whether your program is using a waiver at this time. Now that we've talked about applicable limits, the next slide will consider how to figure out these amounts. So we've already covered how to find FMR, which is published online by HUD using location-specific calculations that are updated each year. Rent reasonableness, by comparison, is determined by each project, really for each potential housing unit. It's based on an assessment of the unit against comparable units in its area. Since rent reasonableness is a bit more complicated, let's go into it a bit more, starting on our next slide. Projects are responsible for setting policies and procedures regarding determining what documentation is required, maintaining documentation in client files, and ensuring comparisons are up to date and appropriate for each unit, given that comparable rents vary over time. On the next slide, we'll consider the number of ways to document rent reasonableness. Examples include a market study of rents charged, written verification from a property owner or a management company, or a review of comparable units. On the next slide, we'll see a sample of how to compare the unit where the client wants with other comparable units. HUD has created this sample rent reasonableness checklist and certification, available online at the URL at the bottom of the slide. You don't need to use this exact form. Whatever sort of form you use, you'll want to ensure that documentation includes the proposed unit and 3 comparable units, and information on those units' location, size, unit type, as in, is it in a high-rise building or a single-family home, for example, the condition of the unit and the age of the unit, as well as amenities and utilities included. You'll notice at the bottom that in calculating the gross rent, you should consider the entire housing cost, including any utilities that the lease says are the tenant's responsibility. On the next slide, we'll consider utilities in a bit more detail. HUD's fair market rent assumes that rent includes necessary utilities, so there are additional steps projects will need to take whenever tenants pay for utilities separate from rent. This may result in a reduction in the tenant's occupancy charge or portion of the rent payment, or in a utility reimbursement to the tenant. CoC funds can be used to cover only eligible utilities, meaning PG&E, water, sewage, and trash, and cannot be used for things like internet or cable. We chatted a bit about clients having a contribution to the rent. So now I'll turn it over to Byla again to chat with us about client income and rent contribution calculations.
Okay, so now we're going to talk about how to calculate rent contributions. And as with all other topics that we discussed today, this is an overview of a very detailed topic. So we're recommending that you use this training as a jumping off point and that you look at additional materials to supplement your knowledge, some of which will be linked to, again, at the bottom of this video. So the first thing to know about charging rent and occupancy fees is that rental assistance programs are required to charge participants rent unless the participant has no income, because then when you calculate their income, you'll just get zero. And again, calculating income is going to be at the basis for how much you're going to charge, along with the other calculation steps we're going to talk about in a moment. The next slides are going to provide the standards for charging rent in permanent supportive housing and transitional housing programs. A really important thing to note is that rapid rehousing programs have different rules and must follow the CoC's written standards for rapid rehousing programs when they charge rent. So again, what we're going to discuss today just has to do with permanent supportive housing and transitional housing programs, not rapid rehousing. Rapid rehousing programs, as I stated, have to follow the San Mateo County's CoC's written standards, which state that each rapid rehousing program will establish its own policies regarding subsidy amount, duration, and the process for reassessments throughout the program. So what this is saying is that it's up to each program to decide how and when to charge rent in rapid rehousing programs. So that's rental assistance. Now moving on to leasing programs, including, as I said, permanent supportive housing and transitional housing. These are not required to charge participants rent, but if they do, they have to follow the guidelines that I'm going to discuss in a moment. And just a note for the purpose of this training today, I'm using the term rent to mean both rent and occupancy fees. So another fundamental thing to know about rent contributions is that there's a cap on how much you can ask for the client. So for rental assistance programs providing PSH and transitional housing, the program participants' rent contribution must not exceed it must not exceed 30% of the family's monthly adjusted income. And we'll talk about how to calculate the adjusted income in a moment. 10% of the family's monthly gross income, or the portion of welfare payments specifically designated by the Public Welfare Agency to meet the family's housing costs. For leasing programs that provide permanent supportive housing or transitional housing, again, the program doesn't have to charge rent at all, but if they do, they cannot charge more than the highest of those three calculations. So again, in order to know what each of these numbers is, your program's going to need to make some calculations. You're going to need to know the household's monthly adjusted income, the household's monthly gross income, and any portion of their welfare assistance, if any, designated for housing costs. And the next slides will outline the steps to calculate the first two of these calculations. And it's going to be, these calculations will use income or expenses which the household anticipates receiving or expending in the 12-month period following the effective date of the income certification. So that's the time period that you're talking about. So unfortunately, this is not just something that you're going to need to do for your clients once. You're going to periodically need to recalculate any rent you ask your clients to contribute. And how often you review this amount is going to depend on the type of program that you operate. For rental assistance, you're going to need to do this initially when the client enters the program, annually thereafter, and on an interim basis as their income changes. You know, especially if the rent goes down, if their income goes down, you want to make sure that you're not overcharging them. For leasing programs, you're going to, again, do it initially, and then on an interim basis, if it's requested by the program participant due to a change in family composition or a change in the resident's income. So again, that's if they're requested by the program participant. It's not required annually the way it is for rental assistance programs. So when you're calculating the client's rent contribution, you're going to need to document the information you rely upon to calculate the rent. HUD calls this documentation verified information. So for example, you're going to need to document the family composition, medical expenses, and other circumstances that impact rent that we'll talk about. And each aspect of the client's life that you'll consider in your calculation, each allowance that you're going to be deducting, has its own documentation requirements. For example, you have to obtain third-party verification of anticipated employment income. And if that third-party verification is unavailable, then you're going to need to document that in the client file. That's just an example. We're not going to get into the rules about how to document the sort of calculation items today. But if you have questions about particular rules around documentation, please reach out to us. So getting into the nitty-gritty now about rent calculation. We have laid out 9 steps that you're going to need to take to calculate your client's share of the rent. The first one is going to be determining the annual income. And then the next 7 steps after that relate to calculating and deducting various allowances to determine the annual adjusted income. And the very last step is determining and factoring in any utility allowances. Step 1, which is the first step towards calculating rent, is determining annual income. So to determine the household's annual income, you're going to want to first determine who is in the family composition, so who is in the household. Then you're going to want to determine all the total anticipated income that is going to be received in the year for in the following year for everyone in the household composition. Then you're going to go through and categorize each source of income as included or excluded. Included income will be included in your rent calculation, and excluded income will be left out. You need to obtain verified information of income to support your calculation. And one tip that we have is that you should document and note your awareness of all types of income, whether it ends up being excluded or included, so that HUD knows that you took that into consideration, even if it ends up being excluded at the end of the day. We are not going to go into what is and isn't excluded today. There are lots of handy tools available online, tables and such that provide detailed information about that we can link to at the bottom of this video as well. And also you can always reach out to us if you have questions about what types of income should be included or excluded. A couple of tips. Remember, you're determining future anticipated gross income. And do not make assumptions about whether an individual or family may or may not have a particular type of income. Always ask. For example, a family without children may still be receiving back child support payments, even if the child is out of the household. And remember that unrelated persons can constitute a family unit. So again, also do not make assumptions about who is and is not going to be on the family composition. Because the income of all adults living in the unit must be included. Okay, now moving on to the allowances that you're going to deduct to determine the adjusted annual income. The first allowance is the dependent allowance. So to calculate this, you're going to want to determine whether there are any dependents in the household and then deduct the appropriate dependent allowances. And to do this, you're going to deduct $480 per dependent from the annual income. This chart provides information about what is a dependent and what is not. Step 3, you're going to want to deduct any child care allowances. So again, you have to deduct anticipated, unreimbursed, reasonable child care costs for children 12 years old and under. And those costs have to be necessary to permit a household member to work, or have to be necessary to permit a household member to pursue education. So some tips for you on this. Remember that some child care costs are reimbursed by CalWORKs or other sources, so make sure not to count those that are reimbursed again. And one other really important factor here is that the child care allowance cannot exceed the income received from work. So it can't be more expensive to pay for the child care than it is to for what you're being paid for your work. Okay, before we get into the next two allowances, I'm going to provide you with HUD's definition of disability, because this will help you determine who is eligible for those next two allowances. So according to HUD, a person shall be considered to have a disability if they have a condition that is expected to be long continuing or of indefinite duration, substantially impedes the individual's ability to live independently, could be improved by the provision of more suitable housing conditions, and is a physical, mental, or emotional impairment, including an impairment caused by alcohol or drug abuse, post-traumatic stress disorder, or brain injury. And then HUD also states that a person shall be considered to have a disability also if they have a developmental disability, which is defined in the CoC program interim rule, or if they have HIV or AIDS. And again, note that disability status is one of the items you're going to need to have documented in the case file, and there are specific rules on that. If you have questions about that, please do reach out. So determining disabled assistance allowance. So this is where it gets a little bit squirrely, because these next two allowances are interrelated. So you're going to need to consider them in tandem. So the first, like I said, is the disabled assistance allowance, and this mandates you to deduct reasonable anticipated unreimbursed expenses for either of the following costs if they enable the disabled household member or another household member to work. So attendant care for a disabled household member or an auxiliary apparatus, for example, an assistive listening device or other device that aids with communication. And you can only deduct up to the amount earned as a result of the assistance. So again, you can only deduct up to the amount that the person who's either has a disability or the household member, up to the amount that they earn working as a result of the assistance. So moving on to the medical expense allowance. So to determine if you need to make this deduction, you're going to ask if the household has a head of household, spouse, or sole member of the household who is at least 62 years of age or is handicapped or disabled. If the household meets the above description, the medical expenses of all family members are eligible for deduction. All right, so calculating these two allowances. So I've told you what these two allowances are, and now I'm going to tell you how to calculate how much you must deduct, because as I said, HUD has intertwined these two allowances. So HUD says that first you add the unreimbursed disabled assistance that you determined in step 4 and the unreimbursed medical expenses from step 5. And if this sum is over 3% of the household's annual income, then the amount that is over 3% is the amount to deduct for these allowances. So again, this stuff is detailed and it's a little bit, it's a little bit wonky. So please do reach out to us if you have questions about these allowances. So step 6 is the elderly disabled household allowance. So in order to calculate this, the adjusted annual income, you're going to need to determine if this allowance should be deducted. And all households, this one's a little bit more simple, all households are entitled to the $400 elderly disabled household allowance, irrespective of medical costs, if the head of household, spouse, or sole member is at least 62 years of age, is handicapped or disabled. So that's a nice flat allowance. Okay, so now that you've calculated any applicable allowances, you're going to want to add up all of the allowances and subtract that sum from the total annual income, which is what you calculated in step 1. And this figure is the adjusted annual income. And step 8 is going to be calculating or determining the amount of the resident rent. So remember those 3 figures that we discussed at the very beginning. Now you know what the annual income is, and now you know what the adjusted annual income is. So you can determine these numbers, right? And this slide tells you exactly how to calculate. And remember that you're going to want to select the highest of these three numbers for rental assistance programs or up to the highest for a leasing program. Step 9, you're going to want to determine if the household should have a utility allowance. And the utility allowance rules apply to permanent supportive housing, transitional housing, and rapid rehousing projects, including projects that do not require participants to pay rent or an occupancy charge. The recipient or subrecipient must allow for reasonable utility costs if utilities are not included in the rent and the resident is responsible for paying utilities. And the way you determine what a reasonable monthly utility consumption would be is to use the local public housing authority's schedule of utility allowances. And here we have linked to the County of San Mateo's Department of Housing schedule for you to review. So the next thing you're going to want to do is, after you determine the utility allowance, you need to do one of the following. So if the cost of the utilities is less than the calculated monthly participant rent, the amount of the participant rent must be reduced by the cost of the utilities. Or if the cost of the utilities is greater than the permitted monthly participant rent, the household should receive a utility reimbursement. And this slide just talks a little bit about utility reimbursement. So if you're going to pay a utility reimbursement, you can do it in any one of the following ways. You can either make a direct payment to the program participant, or you can make a payment to the utility company on behalf of the participant. If you're going to pay the utility company directly, you need to obtain permission from the program participant. You have to notify them in writing of the amount that you're paying. And you have to maintain records of participant permission and of the notifications to the participant. And last but not least, programs have to maintain in client files all documents pertaining to rent or occupancy charge calculations, including verification of anticipated income, verification of anticipated expenses relevant to allowances, the rent calculation itself, and any notes regarding deviations you've made or special circumstances. Again, this can be tricky, and this was a brief overview of a detailed process, so please do not hesitate to contact us with any questions that you have. And I am going to send it back over to Monica to talk about lease requirements.
Great, thank you, Byla. So to start talking about lease requirements more broadly, many people think of leasing and rental assistance as synonymous. However, leasing as a concept is fundamentally different from rental assistance. In projects that receive leasing funds, the project, noted on this slide as the recipient or subrecipient, contracts for the space from a landlord. So the project is primarily responsible for the housing or office space if it's being contracted to provide supportive services. If the space is being used for housing, the project goes on to execute an occupancy agreement with the participant. Occupancy agreements formalize the participant's rights in the housing and specify program expectations regarding continued occupancy in the housing. Sublease or occupancy agreement requirements vary depending on whether the housing is transitional or permanent. So let's consider those differences on the next slide. In transitional housing, a sublease or occupancy agreement only needs to be for a term of at least 1 month and automatically renew for up to 24 months. Whereas in permanent housing, so PSH or rapid rehousing, a sublease must be for a term of at least 1 year and automatically renew. Again, I'll add an asterisk here that in response to COVID-19, HUD has made available a temporary waiver on the 1-year lease requirement for permanent supportive housing participants. Again, this recording is being recorded on June 25th, and you'll want to check with your agency lead on whether your program is using this waiver. On the next slide, we will consider rental assistance projects. So as compared to leasing projects, in rental assistance projects, participants lease directly with landlords. Similar to leasing projects, These leases may vary in length and standards depending on whether the housing is transitional or permanent. Transitional housing leases, again, need to be for at least 1 month and automatically renew for up to 24 months. And permanent housing leases need to be for at least 1 year and automatically renew. And again, check with your agency lead on whether your agency is using a COVID-19 waiver on the 1-year lease requirement for PSH. On the final slide in this section, we will note that whether in a leasing or a rental assistance project, leases and occupancy agreements have a number of required components, including dates, description of the premises, rent and security deposit, and other legal notices and disclosures. This has just been a very quick overview of general CoC lease requirements. So we'll spend some time now getting into more detail for an important set of requirements related to the Violence Against Women Act, starting on the next slide. The Violence Against Women Act, or VAWA, is landmark legislation that recognizes domestic violence is an epidemic and provides a number of legal protections and resources for survivors of domestic violence. With each reauthorization, VAWA has grown stronger and more inclusive, and it includes protections for survivors in HUD-funded programs. Despite its name, VAWA protections apply to all genders. On the next slide, we'll note that VAWA has a broad, inclusive definition of violence, and as Byla noted earlier, it includes protection for survivors of domestic violence, dating violence, sexual assault, and stalking. In this training, we will use the term domestic violence as shorthand. On the next slide, we'll consider required notices to clients. It can be difficult to identify and impossible to predict when domestic violence may occur. So CoC-funded projects need to provide each applicant and participant with a notice of occupancy rights and certification form at each of the following times: when the household is denied assistance, admitted to the program, receives notification of eviction, or is notified of termination of assistance. The notice of occupancy rights must include VAWA protections, including survivor rights of confidentiality and the prohibited bases for denying or terminating assistance, and limitations on VAWA protections, which we'll cover in a few slides. The certification form must be approved by HUD and provide space for the applicant to state that they are a survivor of domestic violence. On the next slide, we will note that several provisions related to VAWA compliance are required for all leases. A statement that the landlord will comply with VAWA, including the prohibition on evicting a tenant due to domestic violence, and that domestic violence against a tenant cannot be grounds for claiming that they've engaged in a, quote, repeated or serious violation of the lease, or as good cause for terminating their assistance, tenancy, or occupancy rights. The lease may specify that VAWA protections only apply during the period of assistance under the CoC program. On the next slide, as I noted previously, there are some limitations on VAWA protections. Tenants may be terminated or evicted for a non-domestic violence related violation, so long as they are not held to a more demanding standard than other tenants, or if the housing provider can demonstrate an actual and imminent threat to others. The standard to demonstrate an actual and imminent threat to others is very high. It's a physical danger that is likely to occur within an immediate time frame and could result in death or serious bodily harm. Importantly, none of these limitations on VAWA protections can be used based on stereotypes. On the next slide, we will make an important point here where evicting or terminating a tenant should occur only as a last resort when there is nothing more that can be done, including options such as transferring the survivor, barring the perpetrator from the property, developing other plans to keep the property safe, or seeking legal remedies to prevent the perpetrator from acting on a threat.
Okay, so switching gears to my favorite topic, housing quality standards inspections. The first thing that you need to know is that all CoC funded housing has to pass in-person housing quality standards inspections. Anyone from your program can conduct these inspections. You do not need to have any sort of special certification to carry them out. And most programs carry them out using their own forms that they've developed in-house. Or they can use one of the forms that HUD has created for the Housing Choice Voucher Program. So why are HQS inspections important? They're important because, first of all, they promote access to safe, suitable housing regardless of income. So HUD, as a policy matter, has determined that people should not have to suffer in substandard housing due to their income level. Everyone deserves to have a safe and sanitary place to live. Having to pass inspection incentivizes landlords to provide better housing to everyone. Inadequate housing is a public health issue. Substandard housing can lead to issues such as increased asthma, lead-based paint poisoning, and other environmental health issues. Also, inspections make sure that all CoC-funded housing meets a standard minimum level of quality. So again, instead of having each agency or person, inspector, making completely subjective determinations that are inconsistent within communities about what is acceptable, HUD has decided that there needs to be some standard minimum levels of quality for housing that's funded with CoC money. Also, HUD wants people to be able to choose where they live, but this means that there has to be some way to inspect private apartments to make sure that they meet this minimum floor. And again, like I have been saying just this past couple moments, these standards are a floor, not a ceiling. They're intended to create a baseline, not to create unreasonable standards that would limit the available housing stock. But again, they're not saying that this is, the best type of housing that you should be providing. It's just, this is the floor. So this slide provides background on the legal underpinnings of this requirement. So the CoC program interim rule requires HQS inspections and describes what needs to be inspected and the frequency of those inspections. So what needs to be inspected? All leasing or rental assistance units paid for through the CoC program. And when do they have to be inspected? Before move-in and annually thereafter. And owners have to correct deficiencies identified during inspections within 30 days. And it's very important to note that subsidies cannot be paid for housing that fails housing quality standards inspections unless owners correct those deficiencies within the 30 days from the initial inspection and the program verifies that all deficiencies have been corrected. Programs have to maintain HQS inspection records for 5 years to demonstrate compliance. We would also advise that programs maintain lead-based paint inspections records indefinitely to show due diligence if issues arise later on. And again, this can't be stated enough, and this is essentially applies to everything that we've talked about in this training thus far, but record keeping is really, really vital. If you can't show HUD that you conducted these inspections and that this happened, then they didn't happen, essentially, for HUD's purposes. So this slide provides a little bit more information about where housing quality standards come from. With the exception of a couple of CoC program-specific occupancy rules we're going to cover in a minute, the CoC interim rule incorporates housing quality standards regulations that apply to HUD's Housing Choice Voucher Program. So this is why so many CoC-funded programs use HUD's Housing Choice Voucher inspection form to carry out their inspections. It's important to be aware that these standards are intentionally vague because HQS regulations are national and they have to cover a lot of different environments, a lot of different areas with different kinds of weather, different housing stocks, urban, suburban, rural. So again, they're intentionally vague. So for that reason, you're going to need to know what your local laws say and what your housing codes say in order to fill in the blanks. You can also look to your local housing authority administrative plan for guidance, even though it's not clear that that's mandated, that guidance will be a mandate for CoC funded programs. They can provide you with valuable guidance if you're just not sure whether something is adequate. In particular, you should be familiar with safety-related local laws, such as those about lead paint, safety, fire codes having to do with smoke detectors, egress, prohibitions on certain appliances in homes, regulations about carbon monoxide detectors, and water and air temperature standards. And where there's a discrepancy between the local law and HQS that have to do with safety, use whichever is the stricter requirement. I want to quickly go over the language commonly used during HQS inspections to describe outcomes and findings if you're using HUD's Housing Choice Voucher Program forms to conduct your inspections. And the form that I'm speaking about, one of the forms I'm speaking about is Form HUD-52580, which we will provide a link to. So these terms apply to both individual items needing to be checked, for example, a kitchen sink, and they also apply to the entire decision about the unit. So for example, the stove might pass or the kitchen sink might pass because they're functional, but the entire unit might fail for other reasons. So there could be individual passes and overall passes. That makes sense. So pass means that the unit or the item passes inspection. Pass with comment means that the item or unit passes inspection, but a note is added about an issue that needs to be addressed, right? It's not a deal breaker, but it's something that the landlord should fix, right? For example, scratches in the floors. Inconclusive means that the inspector needs more information. For example, if the landlord has told them that a piece of equipment is on the way, or if they were unable to check something because they didn't have access to it at the time of the inspection. Fail just means that it's something that's missing or something that's so seriously deficient that it causes a health or safety issue. And if anything in the unit fails, the whole unit fails. So it could be possible that the unit's in great condition, but it's missing a bathroom sink. Okay, that's obviously a fail. But again, if something fails, the whole unit fails, that means that the person cannot move into the unit. And there are no conditional passes, meaning you can't write down on the form, this unit will pass once the landlord fixes the hole in the wall. Fixes have to happen, then the inspector has to re-inspect, and then the unit can pass. So as I stated, housing quality standards are really general. This is on purpose. And so decisions will often be left to your discretion and judgment to fill in the blanks. So for example, HUD will say that the unit has to have a safe lockable door. That's not defined. So you have to really use your judgment and ask yourself, is the door thin with a flimsy lock? Is the lock only unlockable from one side? So things of that nature. And because a lot of these issues are very technical, if you're unsure about something, for example, something electrical, something to do with the plumbing, always consult local law or an expert in the area. And in general, tenant preference is determinative if there's a borderline issue, if it's not a baseline health or safety concern. So communicate with your client about what their deal breakers are. For example, they may be okay to have a very small room. They may be okay with wear and tear that doesn't impact safety. So you're just going to want to have those conversations with them. Another thing to bear in mind is that HUD may be able to provide a waiver if there's a situation in which a unit would fail, but for an issue that's related to tenant preference. So for example, if the unit's a little bit overcrowded, HUD may provide a waiver in high density areas. And you'd seek that waiver by going to your local field office. Just a couple of things, tips about what makes an effective inspector. So you're going to need technical knowledge about what's required. You're going to need to be able to communicate about issues with the landlord and tenant. So we recommend reviewing the checklist with the landlord and tenant so that they know what you're going to be looking for. And you also need to be able to explain to the landlord and the tenant why you made the decision that you made. You're going to need to have sound judgment because of the need to often use your discretion. You need to be objective. So it's not about what you would personally want in a unit, but it's about what's objectively safe and acceptable. You're also going to want to be firm about what the regulations say and what the checklists say. You may be tempted to allow something to slide because you really care about your client and perhaps they're living in a place not meant for human habitation and you want to see them housed. Again, you really need to toe the line and make sure that CoC funds are not being provided to pay for substandard housing. You're going to need to be thorough, and you also want to make sure you're documenting any issues and all the bases for your decision. Again, this may be related to limiting your liability, but also it ensures that you're able to effectively communicate about the bases for your decisions. And it also provides you with a record so that if you forget, why something was a fail previously, you can look back at what your reasoning was. So in this section, we are going to go over the general requirements for private units. So not SROs or shared housing, but just private units. So every private unit must have a living room, a bathroom, and a kitchen. A living room can be used as a sleeping area, and a studio apartment counts as having a living room. With regard to the amount of space per person, this is something where the CoC program interim rule deviates from the HQS regulations. So the CoC program interim rule says that you must have at least one bedroom or living/sleeping room for each 2 persons. And again, like I said, HUD sometimes grants waivers in high density areas. The CoC program interim rule also says that the unit configuration cannot require older children of the opposite sex to share a sleeping room. HUD does not define older children. This is an area for your discretion. And one thing to note is it doesn't matter where people actually end up sleeping, right? HUD is not going to come in and say, well, even though you could have these children sleeping in separate rooms, you're not. It's just that you cannot have a situation where the children are forced to sleep together in the same room because of the layout of the apartment. And again, like I said, this section has to do with private units, but HQS do also apply to what HUD defines as special housing types. So SROs, shared housing, etc. I'm not going to focus on those here today, but feel free to reach out if you have questions about HQS inspections for those types of units. Turning to the details of what you're going to need to inspect, HUD divides rooms up as rooms used for living and those not used for living. So rooms used for living are defined as those that are regularly used and readily accessible. So bedrooms, living rooms, kitchens, bathrooms, hallways, staircases. And an example of a room not used for living might be a garage or an unfinished attic, something along those lines. And this slide provides a brief overview of the sorts of things you'll be looking at in these rooms. So rooms used for living have to have adequate illumination. So you're going to need sufficient natural light or artificial light to permit normal indoor activities. They need to have adequate electricity. So you might want to look at whether there are enough outlets, whether or not the outlets and fixtures work. And you're also going to want to check for hazards, such as exposed, uninsulated, or frayed wires, improper outlet grounding, and just a couple of tips on electricity. When in doubt, go ahead and mark something inconclusive and consult with an electrician. Another thing that we've heard comes up sometimes is the landlord will not turn the electricity on for the inspection, so you're going to want to make sure that the electricity is actually on. And also sometimes it'll be the light bulb that's burnt out, and it won't be that the electricity is not working. So one of the things we recommend is that you bring a couple of extra light bulbs with you just to make sure that you can check it with a couple of different light bulbs. Windows, depending on the room, units have to have sufficient windows. Not all rooms require windows, as I just indicated. So windows accessible from the ground have to be secure. So windows with sills less than 6 feet from the ground are considered accessible. Windows have to keep the elements out. So you're going to want to look for cracks, holes, gaps, and panes. Ceilings, walls, and floors, you're going to want to look for basic soundness and conditions. Lead-based paint hazards will come into play. We'll talk about those in a moment. So each of these areas that I just ran through has its own specific technical inspection requirements to be aware of that we're not going to go over in detail today. So you're going to want to really review your inspection list and the regulations carefully when carrying these out. You're also going to want to ensure that each unit has working plumbing. So looking at the water quality and supply. Also must have adequate hot and cold water. And again, HUD does not set the water temperature standards. Those are based on local law, so you're going to want to need to know those. You're going to have to check for adequate heating and cooling, again, based on local and state codes and what they say about what is adequate. Each unit has to have functioning kitchen appliances, including a refrigerator that can maintain low enough temperature to prevent food spoilage. You are going to want to make sure that the building does not have major structural issues such as buckling walls or roof that's collapsing. The unit has to have smoke detectors, and the specific rule states that there must be at least one battery operated or hardwired smoke detector in proper operating condition on each level of the dwelling unit, including basements, but excluding unfinished attics. And these have to be installed according to the National Fire Protection Association standards. And again, we recommend that you check the local fire code for more details. Buildings have to have sufficient fire exits per local codes. The unit has to have a lockable exterior door, and there can be no major health or safety issues present. For example, mold, infestations, staircases with many steps that lack handrails, things that are fairly obvious. Moving on to lead-based paint. Inspectors also have to check for lead-based paint hazards. Just a tiny bit of history about lead-based paint usage. Lead used to be a common additive in paints because it made surfaces stronger and sort of easier to clean. So lead was often added to paint specifically in bathrooms and kitchens. But in 1978, the federal government banned the use of the consumer use of paint that contained lead. So most homes constructed before 1978 have lead paint, often buried under other layers of paint. And when children 6 years old and younger are exposed to lead dust and chips, this can lead to serious long-term health issues such as hyperactivity, slowed growth, hearing problems, anemia, and so on and so forth. So this is a really serious public health issue. So your inspection process when you're looking for lead-based paint is that if the unit is built before 1978 and it will house children 6 or under, you need to do the following. You need to conduct a visual assessment of all interior and exterior surfaces for deteriorating paint. And when I say deteriorating, I mean peeling, chipping, flaking. Interior surfaces include common areas outside the unit. The owner, if it's rental assistance, or the program, if it's leasing, must stabilize all deteriorated paint prior to move-in or within 30 days of notification if it's uncovered during an annual assessment. Units must be cleared by a certified inspector if the affected areas were more than 20 feet on the building exterior or more than 2 square feet on the interior. So again, they have to be cleared by a certified inspector if they were larger than those areas. And again, before the execution of the lease, the owner, if rental assistance, or the program, if leasing, is required to disclose any knowledge of lead-based paint or lead-based paint hazards in housing built prior to 1978. And they have to provide that to all prospective residents. And lastly, just to note, there are some variations in these regulations. I've been talking about for private units for rental assistance and leasing, but there are different rules for properties rehabilitated or acquired using CoC funding. If you have questions about those, please reach out to us. I'm not going to go through this slide here. This is just, for your own sort of records. These are just some things that we know can be very useful to have during your inspections. And here are some tips. You can use annual inspections as a selling point to landlords. When you're trying to engage with a landlord, trying to recruit them, you can say, we do these annual inspections to make sure that the apartment remains in good condition, to catch any issues. You can also use minor issues that you identify as a bargaining chip to try to lower rent. For example, if there are scuffed floors or other wear and tear that's not a safety issue, you might say, we're not going to ask you to fix this right now. Therefore, can you knock X amount of money off of the rent? If it's an annual inspection, it's really important just to give the tenant, your client, advance notice that you're coming, obviously, and talk to them about any issues that you might find, to see if maybe you can head them off in advance of the inspection, because you don't want the unit to fail, right? Because then you can't continue funding it unless the issues are remedied in a certain amount of time. And again, you just need to remember that you're entering someone's home where they live, and they may feel uncomfortable with you coming in. They may feel as if you're judging their homemaking. So just make sure that they understand that you're there and why you're there, and remember that they might be feeling particularly vulnerable during the inspection. And also, you just want to make sure that you document everything and record it thoroughly. These are links to a few different resources that I've, one of them is the Housing Choice Voucher Form, Inspection Form, a couple of other documents that HUD has created. Just one thing to bear in mind that these are all particular to the Housing Choice Voucher Program. They're not specifically designed for CoC funded programs. They can be useful for your programs, but not everything in here is going to be applicable to you. Okay, and I'm going to hand it back over to Monica to talk about reevaluations.
Great, thanks, Byla. So for our final topic today, we have talked a lot about all of the sort of documentation that you're going to need to collect, especially at the outset of your program's relationship with your client. But we do want to note here as a reminder that your obligations don't end with the one-time certification. There is an ongoing need to reevaluate. This can look a number of ways, including a case note in HMIS or an updated case plan with participant and case manager input that's signed and dated. Most programs do this much more often than annually, so a regular assessment of needs does meet this requirement for an annual assessment. And again, you'll want to check in with your agency lead if there's any applicable HUD waivers to reassessment requirements as a result of the COVID-19 pandemic. So on our final slide of the day, we just want to thank you so much for tuning in. We really appreciate your time and hope this has been helpful for you. As we mentioned earlier, this has been an incredibly brief overview of a number of complex topics. So please don't hesitate to reach out with any questions or concerns. We're here to help, and we can be reached via email at sanmateo@homebaseccc.org. Thank you so much for your time and for your work. We hope that you and yours are safe and well, and we look forward to being able to see you again in person soon. Take care.